Welcome to Section 9.3. We are looking at ultimate liability in court fees, determining which party actually has to compensate the other, or if the costs are simply borne by both sides. Let's look at the legal text. Section 167 states, "An order regarding court fees, whether requested by the parties or not, shall be issued by the court in the judgment or absolute order." In practice, this means the court is legally required to rule on who pays the fees in every single judgment. The parties can bypass this by staying silent. We see this applied in Supreme Court Case 6251/2562. The trial court fixing attorney fees without a request is an assignment of fees. However, the trial court fixing attorney fees at 10,000 baht, exceeding 5%, is unlawful. The Supreme Court is affirming that judges can award attorney fees even if nobody asks for them, but they must stay within the statutory 5% cap because fee limits are a matter of public order. The court must issue a fee order in 5 specific scenarios: upon a final judgment, when a case is dismissed from the docket, during interlocutory rulings, for disputes separate from the main issue, and in retrials. Because these rules are classified as protecting public order, the judiciary retains absolute control over fee allocation. The court ensures the state's procedural costs are addressed, regardless of the litigant's conduct. This brings us to the scope of the court's power. Section 161 states the court may use its discretion by taking into account the reasonableness and good faith in conducting the case. The default rule is that the loser pays. However, this section gives judges absolute authority to deviate from that rule. If a winning party acted in bad faith, the court can order them to pay their fees. Supreme Court Case 6760/2561 confirms, the appellate court has the authority to order the plaintiff to compensate the defendant for court fees in the trial court. This means even if you lose at the trial court but win on appeal, the appellate judge can still force you to pay the trial court fees if they deem it reasonable based on your behavior. Here is the text for Section 168, which restricts challenges. In cases where parties may appeal, parties are prohibited from appealing solely on the issue of court fees, unless the fees were not fixed or calculated correctly. You cannot file an appeal just because you are unhappy with who was ordered to pay. The only valid ground for a fee-only appeal is a mathematical error in calculation. Section 169 directs the court director to prepare the final fee account, and 169/1 states, if a person owing court fees defaults, the executing officer may execute against their property. The administrative side is strictly regulated. The court director finalizes the bill. If a party refuses to pay it, their assets can be seized exactly like any other judgment debt without needing a separate lawsuit. Granting judges broad discretion while making the final calculation difficult to appeal prevents fee disputes from indefinitely stalling the conclusion of a case. To apply this discretion, the law uses a 6-part allocation matrix for determining ultimate liability. We begin with general cases. Looking at the text outlining the general rule, the losing party typically bears the costs. But in non-litigious cases, like a petition to manage an estate where there is no opposing party, the person initiating the case pays the fees. When multiple parties are involved, we look at Section 162. It states, persons joining as co-plaintiffs or co-defendants shall be jointly liable for court fees, unless liable in equal parts, except when they are joint creditors or joint debtors. If several plaintiffs or defendants lose together, they split the court fees evenly. The exception is if they are legally joint debtors, in which case the winning party can pursue any one of them for the entire fee amount. For cases that end in a settlement, Section 163 dictates, if a case is finalized by agreement or compromise, each party shall bear their own court fees, unless agreed otherwise. Settlements rely entirely on the contract between the parties. They can agree to whatever fee split they want. But if they draft a settlement and forget to mention court fees, the law automatically requires each side to pay their own. These first 3 rules establish a baseline. They allow parties to control their own costs in a settlement, while maintaining strict mathematical parity when a judge has to rule against multiple defendants. The rules shift when dealing with strategic litigation. According to Sections 135, 136, and 164, a defendant can deposit money with the court to satisfy a claim. If a defendant deposits the full amount they believe they owe, and the plaintiff refuses to accept it and insists on a trial, there is a risk. If the final judgment does not exceed that deposited amount, the plaintiff is responsible for all court fees incurred after the deposit was made. Section 165 applies a similar logic to non-monetary settlements. In the case of satisfying a debt, if the plaintiff accepts, the defendant is liable for fees, unless the court sees fit to order otherwise. If a defendant offers to transfer an asset, like a plot of land, instead of cash, and the plaintiff unreasonably refuses an offer the court deems sufficient, the judge will shift the burden. The plaintiff will end up paying the fees for dragging out the case. Section 166 directly addresses misconduct. It targets actions taken through fault or gross negligence that cause unnecessary proceedings. If any party intentionally wastes time, fails to appear, or commits gross negligence, they must pay the fees for that specific segment of the trial. This applies even if they eventually win the overall case. The Civil Procedure Code actively uses court fees as a behavioral tool. It rewards efficient resolution and directly penalizes stubborn or abusive litigation tactics. Once the trial ends, we enter Section 9.3.2, Liability in the Execution of Judgment. Section 169(2) dictates the mechanics of getting paid. It states, by deducting from the money obtained from the seizure, attachment, sale, or distribution of the property of the judgment debtor, the judgment debtor is responsible for the costs of their own execution. When an asset is sold at auction, the executing officer takes the court fees out of the proceeds first, before any money is handed over to the creditor. Section 366 expands this liability to third parties, covering anyone acting as a guarantor in court. If a party uses a guarantor to secure their release or assets, and that guarantor defaults, the law treats them exactly like the judgment debtor. Their assets can be seized for fees without filing a new lawsuit. The third paragraph of Section 169(2) handles joint property. In the case of execution, dividing joint ownership or inheritance, deduct from the money obtained from the sale. In a forced sale of shared land or an estate, the execution fees are deducted directly from the total sale price, right at the start, before the remaining funds are distributed to the co-owners or heirs. During the execution phase, the state ensures its own administrative costs are prioritized. The system is funded directly by the individuals whose unpaid debts necessitated the enforcement. There are also consequences when an execution is halted. Section 292 governs the withdrawal of an execution. If the debtor finally pays what they owe to stop a property seizure, the debtor is liable for the execution fees. However, if the creditor simply changes their mind and withdraws the request, the creditor must pay those fees. Finally, Section 169-3 addresses wrongful execution, focusing on actions lacking good faith or involving gross negligence. Just like in the trial phase, bad faith in the execution phase carries a penalty. If a creditor maliciously seizes assets they know aren't needed to satisfy the debt, they will be ordered to pay the extra enforcement costs. A party injured by this kind of overreach has a strict 7-day window, starting from when they learn of the bad faith conduct, to petition the court to shift those fees. The Thai Civil Procedure Code creates a continuous loop of accountability. From the initial filing to the final auction block, every procedural cost incurred is systematically assigned to the party whose actions made it necessary.